evening, everyone. Welcome. So for those of you who don't know me, my name is Susan Curtin. I am the director at the Council on Aging here in Norwell. We'll wait. Quite all right. So if anybody else has phones, please make sure to take this moment to silence them. That would be great. So we are thrilled to have you all here. Some of you, this is your first time with us. For others, you've been with us for the past couple of weeks. So we began an initiative called Live Well, Age Well, Norwell. And the idea is to try and bring a variety of educational topics to not just older residents in the community, but also, hopefully their family members. So just as a little bit of housekeeping, we are recording this session today. Spotlight TV is here in the back. You can't see them, but they can see you. So this will be recorded, and we'll be showing this actually on cable TV locally here in Norwell, and it will also be available for streaming as well. So we have 5 panelists today. This is our third in 5 series. Our topics today is Do I Really Need? And this discussion will be about different types of documents, healthcare documents, legal documents. We also have our VSO, our Veteran Service Office, here to talk a little bit. So I'll introduce each of the speakers. In the past, what we have done is we have asked to hold questions to the end. Hopefully, most of you who are maybe new or not new, hopefully have something to write on, just to make it easier. If you're not comfortable asking the question, because knowing we are being recorded, we will allow people to write the question down and we will pose it for you. So Leanne, you want to raise your hand for me? So Reverend Leanne Walt is here from UCC. She'll be one of our ambassadors to take your questions. Dee Dee, can you hold up your hand? Dee Dee Rogers is our outreach coordinator for the Council on Aging. She'll be happy to take your questions as well. So feel free to write them during the course of the presentation as you think of things, and we'll ask them at the end. So we do have 2 more presentations coming up, and we meet every other Tuesday. The next presentation will be on creating your support circle, which will be a combination of things, not just talking about the services that might come in and support you, but who are the groups locally and who's part of your group that would help you in the time of need? Who are the people you would call at 2:30 in the morning? So we welcome you to join us for that. And then the last of our series will actually be on tough conversations, and that will be talking about your care goals and end of life. So we invite you to join us for either one of those. If you plan to join us or know someone who would like to, if you have not pre-registered already, we ask that you do so that we know how many people to plan for seating and for food. So thank you all for being here. So with that being said, I would love to introduce David Osborne. David will be our first speaker. He is the Veteran Service Officer here in the town of Norwell.
Hi, everybody. Probably most of you don't know me because I haven't seen many of you at the Veterans Office, but I can give you a brief rundown, and I look forward to your question time because the veterans thing is spread out, large, difficult, et cetera, et cetera, et cetera. So the quicker you get to an individual case, the better I can help you. So a brief note about what the veterans agent does. There's a myriad amount of forms that are used for almost all benefits that are given. Let me back up a little bit and say benefits basically come from the VA, which is run by the federal government, or from the Massachusetts Division of Veteran Services, which is, of course, run by the Commonwealth. The Commonwealth's requirements are a little bit simpler, a little bit easier, and a little bit less dependent on what you might have for assets than the federal government, but not a lot less. So my basic job is to contact or answer contacts from the folks in Norwell, see what we can do about lining them up with what might be available. Things that are available these days, if you watch TV, you would almost think you're going to inherit the world. Believe me, none of that is true. Almost everybody is making money off that somewhere or other, and the benefits are not so much different than they were a couple of years ago. Veterans with serious health problems are fairly easy to get help for. Veterans without those things are not so easy to get benefits for, and it takes a while. But it's well worth applying if you think you have an issue, especially if it came from service time. If you don't have an issue that came from service time, there's no need to give up. Just come on in, talk to me, see if we can do anything. Such things like that might be hearing, some disability that was with you for a long time. Maybe you never made a report in the service. Maybe it came after the service. That's still a reasonable case to look at and see if something can be done. Let's see. A little note about hearing, because I get a lot of veterans coming in to talk about hearing. If and indeed you have a hearing problem, as most of us do, when we get to be an advanced age, the government doesn't really want to give you a hearing aid. They'll look for every excuse they can. However, the VA will insist that you get tested in their facility, which is very straight, very honest, and very good. And once you've done that, your prospects are much better, especially if they agree that you have a problem. Can I take questions now, Sue, or do I wait? Okay. All right, so I think that's all I have to say at the moment. Oh, yes, we did mention documents. And documents is about 90% of the entire thing. The first thing, if you even want to come to the office, is to give me a call. For you of those that are taking notes, the number at the office is 781-659-8004. And the first thing I'll need to see from anybody is their DD-214. That occurs in 2 or 3 different forms, but usually you'll find it at the lower left-hand corner. It's your discharge paper when you walked out. They change over time, they change per service, et cetera, but you got something when you left. If you do not have that paper, and you enlisted in Massachusetts, it's quite likely I can get it for you very quickly. So if you don't have that paper, you're thinking of give me a call in advance, say, listen, I don't have my DD-214, I don't have any separation notice, and give me your information, and we'll see if we can't get you started on the right foot. The other documents are long, arduous. I can just tell you, maybe in a bit of a humorous vein, the VA sent all of us a notice the other 3-4 months ago. They have taken form such and such, which was 9 pages, and made it much simpler for us. It's only 11 pages now. So you're going to need help with all that stuff, and the office number, I think, is the most important thing. That DD-214 is kind of important, that we get it to get going in the right direction. But I urge any of you that have a problem, that think you might be helped, just give me a jingle at the office. I'll get back to you. We'll settle out the problem that you have individually, see what we can do.
Thank you, Dave. So we recognize the fact that not everyone here today is a veteran or a spouse of a veteran. And so I wanted Dave to at least kind of give a very general, brief idea of the information that you might need to come visit him, or if you have a family member who might be a veteran that needs some assistance. We will plan to do a specific veterans benefit presentation in the future, so those people who may have very specific interest in that will be able to attend. But we wanted to at least give a highlight to that, because it is an important part for trying to access services going forward. Our next speaker is Joanne Calabro, and she is a nurse with the VNA, and Joanne is here to talk about some healthcare documents for you.
Hello. So I am here to discuss some advanced directives forms, which is usually, there are 3 forms. There's a MOST form, which is a lot of us will call it the pink form. It goes over all types of end-of-life decision-makings. Do you want CPR? Do you want to be vented? Do you want a G-tube? Do you want dialysis? So it's very specific as to what it entails. There's also a form that is just called a do not resuscitate form or a comfort care form. That basically says if you were in the home or even in a hospital, a nursing home, if your heart were to stop, you would not want it restarted. There's also another form that is called a healthcare proxy that designates who you are picking to honor your wishes. And that's, sometimes you have to be very careful with who you pick, because once you have your wishes written down, you hope that the person that you pick will honor them. The biggest thing about whether or not to choose if you want your heart restarted really depends on what you have going on in your body. If you're a regular person, you don't have any comorbidities, you don't have any type of diseases or anything, and you have a sudden cardiac event, like you're at the gym, you're on the treadmill, and you have a sudden cardiac event, and somebody initiates CPR, they have a defib, you are very likely to have a favorable outcome, which means you'll get to the hospital, they'll fix the issue, you go to rehab, you go home. What happens is, as our bodies age, and we have a lot of advanced comorbidities, whether it's heart disease, diabetes, kidney disease, as those diseases progress and our bodies get older, doing CPR has a much poorer outcome. Even if you were in the hospital and you had an acute event where your heart would have stopped and you have a lot of advanced comorbidities, there's a 1 in 6 chance that you will survive from when you initiated CPR to when you walk out the door. And there's many different studies about it, but and I have a lot of discussions, I'm actually a hospice nurse with my hospice patients that are still full codes. When we do CPR, it is uncomfortable, it is breaking ribs, it is trying to restart your heart. And if we're doing it in a home setting or a nursing home setting, the outcome is even lower than if it was done in a hospital setting. So the whole big piece is quality of life. Nobody can tell you when you have CPR how you are going to survive from it. And if somebody tells you you'll come back exactly the way you are, they're lying. Because as your body is having lack of oxygen, it affects everything. And if you already have a lot of comorbidities going on, it just becomes a lot more uncomfortable to survive and carry through to the end and go home. So the biggest thing that we say is you have to have discussions about how do you want to live the rest of your life. And we're not talking, I had a major surgery, I read the report and it said I was a presumed full code, and I thought, well, yeah, I'm a full code, I want everything done. But my mom, who is 78 and healthy, she had melanoma in her eye 27 years ago, but is healthy. But she's like, yeah, if something happened to me now, I'm 78. I don't want, you can try CPR if I had an acute event, but after that, I'm done. She's like, I don't want anything done. I just want to die peacefully. It's okay. So I know that. My brothers don't know that, but that's a different story for a different day. So it really does become, what are your goals? What do you want? And sometimes we don't think of it until you have an acute event. And that's where it's really important that you write these things down and you pick someone that's going to honor what you want. Because very often those things can shift and change, and it becomes hard. So it really is knowing that CPR is not what you see on TV. It is the aftermath. Like if you ever saw like an ER show where the ER is a mess and there's stuff everywhere, that's what it looks like. It's not kind to your body. It's pressing on your chest to start your heart. And they still say there's rescue breathing, there's all kinds of things that are part of it. But the biggest thing is if you have advanced chronic illnesses, you really kind of need to think about, what do I want to put my body through? And what risk am I taking that if I survive, am I going to be in a vegetative state? Am I going to be wheelchair bound? Am I going to not be able to tell the people that I love them? So these are all the conversations that we talk about, that we want people to have the information. Because the more information you have, the better informed decision that you can make. And it's scary things to talk about, but it really does become, what are your goals, what are your wishes, and write them down and pick someone that's going to do it, because CPR on a healthy person with an acute event is a very good outcome. CPR on a person in a hospital setting with advanced chronic illnesses, there's about a 15% chance that you will make it from the event out the door. And that's not even saying you're going to go out the door the way you came in. So it's really just food for thought and preparing for end of life. Thank you.
Thank you, Joanne. So we talk to people, we get questions about the MOLST form and DNR and things like that pretty frequently. So that we were glad to have Joanne come and talk about that. And I'll ask a question about MOLST later on about that. But Joanne actually has copies for us that will come at the last session when we do the end of life. So those will be available for you if you join us for that particular event. So MOLST, MOLST. And I'll have Joanne come and talk about it at the end. So thank you. So let's see, we have a tag team coming up now. So I would like to introduce elder law attorneys Alexis Levitt and retired elder law attorney Holly Harris, who will come and talk to you about some of the things that we need to take into consideration for estate planning.
Okay. All right, I'm going to start off this tag team. I pressed arrow down, it didn't go down.
I am.
Uh-oh.
Yep. There we go.
So the right one?
Yeah, either one, down away.
Okay. All right, great. So Alexis Levitt, elder law attorney. I might not be able to stand still. I'm not good at that. I might end up walking around. So Holly and I are going to talk about basic estate planning documents tonight and planning for special needs children. So, okay, I can't sit still. All right. Let me see if I can figure this out. Hello. Did that work? Yes. Okay, so this is what we're going to be talking about. Okay, so I'm starting off with a trick question. What is the most important estate planning document that you can have? Don't be embarrassed. You can give me the wrong answer because it's a trick question. A will. Thank you. That is the wrong answer, and that's the answer that everybody gives. Yes, Holly?
Your attorney's phone number.
But not at 2:30 in the morning. So, okay, the most important estate planning documents we can all have are the healthcare proxy, which Joe was talking about, and the power of attorney. So, what are these? You've already heard a little bit about, or a lot, I should say, about the healthcare proxy. So, Sorry, I just noticed the colors on my slides changed. So what is a healthcare proxy? So this is a document that you sign, right? Joe said there's 3 medical documents out there that she likes to talk about. So one of them is the healthcare proxy. So that is the document that you sign with, sometimes with your doctor's office, sometimes with an attorney. And that is where you are naming somebody to make your healthcare decisions for you during a time that you can't make or communicate those on your own. So what I always want to stress with people is that you're going to sign a healthcare proxy right now, and then it's going to go sit in your drawer. You are still in charge for as long as you're able to make your own decisions. The healthcare proxy springs to life. Someone else becomes your decision maker only when your medical team says that you really can't make decisions right now. So the big question is, who do you name? So you want to name somebody who you trust, somebody who is going to honor your wishes. So all the questions that Joe was saying you need to ask yourself, you want to make sure you name somebody who is going to honor your answers to that those questions. So because we have all met people, and this might be a description of your family, it might be a description of your best friend's family, we have all met people where one child will say, my mom wants me to pull the plug and I'll never be able to do that. So you don't want to pick her. So if you want the plug to be pulled. So you want to be thinking about who to name. And I'll stop right here and also talk about some people don't have that person in their life who really is the obvious person to pick for the job. So sometimes we have solo agers. Sometimes we have people who maybe never had kids and their nieces and nephews live far away, or they're not close to their family, et cetera, et cetera. So I just want to let you know that there are people out there who are happy to serve as your healthcare proxy if you need somebody to do that. I have a list that I keep of local elder law attorneys who like to do that. They enjoy that role. So just so you know, if you feel like, well, I don't have anybody to name, there are people out there and we can get you those names. Oh, that third bullet. Oh, sorry, I should have said. So I gave you handouts, so if you've got my slides in front of you, you can be taking notes. We left room for taking notes. So the third bullet is very important. If I go into, right now, so I have a healthcare proxy, right? I am over the age of 18, therefore I needed to sign a healthcare proxy. When we turn 18, there's nobody who can legally speak for us anymore. So we turn 18, we sign a healthcare proxy. I'm sure everybody here on their 18th birthday signed a healthcare proxy. Okay, so I have a healthcare proxy. It is sitting in my filing cabinet. If I go into surgery for those couple of hours where I am just on another planet, I can't make my own decisions, right? So that is when my husband, if he's not here, my brother, they are who I've named, that they will be my decision makers. So this is very important because people ask me this. A few hours later, as I start to come back to myself, I'm able to think again, speak again, I become my own decision maker again. So I want to make that very clear because some people are afraid that like once my daughter takes over, is that it? Well, no, it's only during those periods where you can't think or communicate your own healthcare decisions. So all of us need to sign a healthcare proxy. This does not cost a lot of money. There's a great one online. If you go to Honoring Choices, you can just Google Honoring Choices Massachusetts. There's a great sort of like not a state-approved one, but Massachusetts medical community has approved the one that is on their website. It is better to do one with an elder law attorney, so I always say to everybody who walks into my office, they've done the one from the website, and I say that's great, but if you're here, we're gonna do one that's even better. And so here's why. If you're working with an elder law attorney, I'm not gonna go through everything, but you can just see the state form doesn't address a whole bunch of things, and we are allowed to write all sorts of extra provisions into our healthcare proxy. And I won't go into it, but I think the visual gets the point across. So what happens if you don't have a healthcare proxy? You go to guardianship land. We don't want to go to guardianship land. Has anybody had to deal with this or watched other people deal with this? It's awful. So if somebody does not have a healthcare proxy and comes into a state where they can't make or communicate their own decisions, no hospital is going to touch them or the nursing home is going to say, sorry, we can't help this person, or their doctor's office is going to say, sorry, we can't help this person, because they don't have capacity to tell me what to do, to say yes or no to what I'm offering. They don't have a healthcare proxy who can say yes or no to the choices I'm offering. So family, guess what? Off you go to the probate court to guardianship land. So it's the probate court, it's money, it's time, you gotta deal with lawyers, it's emotionally draining, so you don't want to go to guardianship land. And it's gonna cost you, by the way, so you, the person who did not sign that healthcare proxy, this is gonna cost you several $1,000s. So you don't wanna go there. So, and I'm gonna tell you one really bad story to really stress this point. I had a guy at a nursing home that shall remain nameless. He was on the rehab floor. When you're on the rehab floor, Medicare and your supplement pays for that. He was there to stay. So they needed to move him over to the other side of the building to the nursing home floor. He didn't have a healthcare proxy. He had dementia. He was not able to sign his own discharge papers to move from rehab to long-term care. We had to go to court, spend thousands of dollars and several weeks getting a guardianship so that they could wheel him down the hall from rehab to long-term care. So in addition to the thousands of dollars they had to spend, he really had to spend on guardianship, it was also $450 a day for every day he was sitting in the rehab room waiting to go over to his long-term care room. So, have I made the point enough? We all want to have a healthcare proxy? All right. So the other key document that we all want to have is a durable power of attorney. So that healthcare proxy is to legally empower others to make your healthcare decisions. A durable power of attorney is to legally empower others to handle your finances. So while you're living, your power of attorney can help you pay your bills, sell your house for you, rent an apartment for you, sell your car for you, hire a roofer for you. So call up your retirement account and say, I need more money this month. So your POA, your power of attorney, can do all sorts of businessy financial things for you while you're living. So again, we turn 18. Nobody is legally authorized to do these things for us. Everybody says, oh, but my wife can call up my IRA. Well, no, she can't. They're not going to talk to her. They're not going to take instructions from her unless she happens to be your power of attorney, and you fax that power of attorney off to Fidelity, and then they'll talk to her. So remember we said with the healthcare proxy, that person's power only comes to life when you're in a state where you can't make or communicate your own healthcare decisions. POA is very, very different. And it has to do with the history of how these documents came to be and our set of laws. But when you sign a POA, whoever you've named, their power comes to be immediately. So I have a power of attorney document sitting in my filing cabinet. Technically, if he really wanted to, my husband or my brother, I've named them both, they could go out to the bank and, I don't know, sell my half of the house out from under me, take out a mortgage in my name that I have no idea about. So a power of attorney has lots of power, so you want to be sure that you are naming somebody who you trust. So a lot of people just automatically name, their spouse, and then, well, my number 2 will be my oldest child. So we always have a conversation. Who in your universe, your spouse, your children, your best friend, your nieces, your nephews, who in your universe is the right person for the job? Who do you trust with your money? Who's good with dotting their I's and crossing their T's and paying bills on time? So that's the conversation that we always have about who to name. And again, the same thing I said on the healthcare proxy side. If you are a solo ager and you don't have anybody, or even if you're not a solo ager, if you don't have anybody appropriate in your life, if there's nobody in your tight universe who you trust with your money, we have a list of local attorneys. I don't do this, but I have a list of friends who like to serve in that role. Power of attorney has to be done by an elder law attorney. In Massachusetts, unfortunately, there is no free version online. Other states have them. We should have them, but we don't. Not yet. So the healthcare proxy, you can go to Honoring Choices and download that, the one that's there. There is no such thing as finding a Massachusetts power of attorney on the internet. If you find a Massachusetts power of attorney on the internet, it is a scam, it is bogus, run far away from it. So you definitely have to do this with an elder law attorney. We're gonna skip this. Oh, what happens if you don't have a power of attorney? You go to conservatorship land. So if you are, let's say you develop dementia and somebody's got a, let's say you want to, or your family thinks the best thing would be to move to assisted living. Costs a lot of money, you've got to access your bank accounts, right? Well, if you have dementia, you're not paying your own bills anymore. If you don't have a power of attorney, there is nobody who can get into your bank accounts and pay the assisted living for you. Do you think that assisted living is going to let you move in if nobody can pay them? So somebody's going to have to go off to court and go to conservatorship land. And again, we don't want to go there. It's time, it's money, it's lawyers, it's emotionally draining. So what is the moral of the story? Whoops, not that yet. What is everybody going to do, like tomorrow morning? Healthcare proxy and a power of attorney. Thank you. All right, I know I really beat those and I went on and on, but that's how important they are. On the same topic, a lot of people like to add their child to their bank account as a joint owner. Because quite honestly, when you walk into the bank and you say, I want to add my daughter to my account so that she can help me pay the bills, which is fabulous. Like, it's a very good thing to do to position your daughter to be able to help you pay your bills. That is a good thing. What drives me crazy is the bank staff says, great, let's add her as a joint owner. So if your daughter is now a joint owner of your money, she is now a joint owner of your money. She can take all your money and go to Aruba if she wants to. She probably won't, but she could. If she gets divorced, do you think that divorce attorney, her husband's attorney, is going to get really excited about this account that she's on? If she gets into a car accident, do you think that personal injury attorney is going to get really excited about this account that she's on? So I don't like naming children as joint owners. You want her on there in a way to help you pay your bills. That part is good. So we do it a very different way. I always tell people, go to the bank, add her as a power of attorney, right, which we were just talking about. You can go into the bank and you can say, check off the box that says add child as add a person as power of attorney and type her name in that box. You can do that. So that is the best way to get your child on there and a way to help you pay your bills. So nobody here is ever going to make their child a joint owner on their bank accounts again, correct? Okay. All right, great. All right, yes, okay. So, wait, you didn't see that. All right, so that's what I have to say about, that is mostly all we're going to talk about, with a little asterisk, when it comes to helping you during your lifetime. Next thing we're going to talk about is wills and beneficiaries and trusts. Susan said she gets a lot of questions about these things. So we're going to switch gears. Now we're going to talk about inheritance. So and we can take any questions on healthcare proxy and POA at the end. So for inheritance, there's a couple different ways to set up your estate so that whoever you want will end up getting your stuff after you die. One way to do it, kind of the one that everybody knows about, is the will. Anything that is going to funnel into your will is an asset that has your name and your name only on it. So like my car is in my name, so like my car has to go through my will after I die. Anything that's in just your name goes through the will, goes through the probate court. Anybody here heard stories about things getting trapped in probate court forever and ever and ever? Yes? Yes. So we're going to talk about how to avoid that when we can. Another way to deal with inheritance is to name beneficiaries on accounts. So if you've got an IRA, a 401k, you probably named beneficiaries on those accounts. So that's those, because that asset is now, it's not just in your name, right? It's got someone else's name on there as a beneficiary. It's not going through your will, so it's not going through the probate court. So this is a nice, easy process for spouses, for kids, for whoever you're naming. It's easy to inherit the money when you've been named a beneficiary. Another way to deal with inheritance is to set up a trust. And the bonus about setting up a trust is that whatever you put in there, you might put your house in the trust, you might put a bunch of your money in the trust. It makes an easy inheritance process for whoever you've named to take everything later on. But the bonus about trusts is anything that's in there, your house, your money, etc., your successor trustee, whoever you've named as your next trustee, can step in and help you while you're living. So we like trust, they do double duty. So to talk more about trusts, Susan pulled Holly Harris out of retirement to come see you tonight and teach you all about trusts. How do you want to do this?
I'll take that.
Okay, good.
Hello.
You want me to stand here?
This is called Making the Courtroom Your Own. Those are my props. This is my costume. You're my audience. My job tonight, as I perceive it, is to take the mystery out of trusts. Before I get there, though, I'm going to pick up where Alexis left off with wills and probate. I have here a will. This says it's the will of little Mary Lamb. It was signed today, and it was signed in front of 2 witnesses, and it was notarized. This is little Mary Lamb's will that she made with the help of an elder law attorney who advised her about the issues that her particular situation brought up. There were arguing children. There was a valuable antique car. There was an oil spill on her property out in western Massachusetts. There were a lot of issues in that case. And working with the attorney, little Mary Lamb worked out those issues. As Alexis said, if Mary Lamb, little or otherwise, owns property in her own individual name with nobody else's name on it, no beneficiaries, no instructions to a bank to pay on death after the account owner dies, no instructions to Fidelity or Vanguard or Putnam to transfer this securities account to someone else after Mary dies. Those other properties just in Mary's name will be governed by this will. This puts little Mary Lamb in charge. as Alexis said, those kinds of property governed by this will are going to have to go to, dun dun dun, probate court. In my humble estimation, and I used to do probate work, I know Alexis still does it as well, probate's not the worst place in the world to be. It can be arranged so that assets, money and other, are not stuck in probate forever and ever and ever. A well-planned estate and a diligent probate attorney will get that process concluded as soon as possible and will keep the expense to a minimum. I'm not going to get into details of probate. There are volumes, multiple volumes in lawyers' offices that tell them how to get into probate and get out of probate. But let me say that little Mary Lamb has set this up so that she has chosen who will be in charge, and she knows that the property governed by her will go to probate where the person or people that she has chosen to be in charge will, unless they are not suited to be appointed, they will be appointed as personal representative of her estate. We used to call people either executors if they were named under a will, or if there was no will and there was still probate property, the person that the court appointed was the administrator. Well, we don't have to worry about that anymore. They are all personal representatives. The personal representative will be appointed, and then the issue becomes who gets what and how does it get delivered. In essence, those are the things that happen in probate court. Personal representative gets appointed, and the will, once blessed, or if contested, once that will contest is resolved, the will, as settled, will rule, and it will say who gets the property. Now, how is the property going to be delivered? Well, remember who got appointed as personal representative? The personal representative will deliver jewelry, will write checks to distribute money gifts, will do a deed of distribution under our new Massachusetts probate code to transfer title to real estate. And that's all that's happening in probate court. But remember that it's who's in charge, who gets what, and how does it get delivered. The what, the who gets what, the what is only and ever what I think of as orphan property. If Mary died and her name is the only name on whatever asset that is, that asset, after Mary's death, before probate, does not know who its next owner is. And it doesn't know how it's going to get there. Doesn't matter if it's a piece of jewelry, a bank account, or a piece of real estate. Who's going to deliver me? Who gets me? And who's going to deliver me? Mary Lamb set it up so that she was in charge. Just as with the healthcare proxy and the power of attorney, however, if someone does not do a will, there's no will, and there's orphan property, valuable jewelry, collectible artworks, real estate. Oh my goodness, Massachusetts real estate, very valuable. Somebody is going to want that. And without a will, that orphan property is still going to go to probate. But now, little Mary Lamb is not in charge. Now, once again, it's those books on the bookshelf in not only the lawyer's office, but the judge's office, and in the library of the probate court that say, under the statutes of Massachusetts, these are the people who might be appointed, whether or not that list includes someone that Mary Lamb might have chosen. And this is where the property will go, depending on Mary Lamb's situation. Did she have a surviving spouse? Did she have kids? If there was no spouse and there were no children, are there any surviving parents? There's no provision in those statutes for a gift to any charity. There's no provision in those statutes for any gift to a friend or a beloved neighbor or a more distant relative. You need to make those choices yourself. Be in charge, make a will. Knowing that the will governs only orphan property, and the orphan property and the will be in probate. Work with an elder law attorney. They can simplify it, speed the process, and minimize the expense. One of the ways that Alexis mentioned of avoiding probate is during lifetime, you could set up a trust. Look, I have a trust. This is different, though. This is not little Mary Lamb's trust. This was in a different case. In this case, A and B create the ABC Trust. And it was signed by A and B and a trustee. Here we are back at trusts. And here we are getting rid of the mystery. I want to ask you if any of you would be so bold as to say, I can tell you what a trust is. Anybody want to stand up and give a crack? I'm going to make it easy. Honestly, it's just one way of holding title to property. We've been talking about little Mary Lamb and her individual, personal ownership. And if she owns all by herself, it's orphan property, it goes to probate. But if instead Mary has set up a trust, then Mary doesn't own the property. The trust owns the property. It doesn't matter, again, what we're talking about. It can be real estate. It can be securities in your investment account with any investment brokerage. It can be bank accounts, timeshare interests. Whatever is put into the trust becomes the owner of that property. Now, there are tax advantages, as many of you probably know, to owning your property in your individual name. For instance, the ability to deduct mortgage interest payments on your principal residence, the interest to deduct up to a certain limit real estate taxes. Working with an elder law attorney, language in the trust document can preserve those tax advantages. So the individual no longer owns the property, the trust owns the property, but the tax advantages follow the property into the trust. So my image for you to take away is this trust bucket. That one's red. This one happens to be seasonal, but this is how it works. Think of it as the bucket is where the property goes. The second part of the bucket is the handle. The handle is always held by the trustee, and a trustee can be a an individual, a set of individuals, a professional individual or trust department, including a corporate or institutional trust department. Rockland Trust Company, for instance, and Citizens Bank and Bank of America all have trust departments. So the trustee holds the handle of the bucket and manages and administers whatever is in the trust bucket for, and this is your key phrase, for the benefit of the beneficiaries. Okay? So we've got property held in the name of the trust, trustee manages, and the beneficiaries, imagine their names written right on the outside of the bucket. A and B, in fact, made their trust for the benefit of Abel, Baker, and Charlie, and I put him in there because I'm married to him, but you would be working with your attorney to decide who your beneficiaries are and when they get access to it. If A and B, let's say two spouses are making this trust for themselves and their child, Charlie, then they can, A and B, Abel and Baker, can say, Charlie doesn't get anything till after we have died. Those are the kinds of discussions that you have with your elder law attorney to decide what goes into your trust. You may be thinking, okay, so we've done what, and we've done where. Why do we create a trust? Alexis already mentioned one reason, avoiding probate. There's also privacy. Jacqueline Kennedy Onassis died without a trust, and her will and all of her orphan property, I'm sure it wasn't all orphan property, but all of that probate property went through the public probate process. If she had had a trust, that would not have been open for reporters and curiosity seekers worldwide. The administrative convenience. Sometimes a family inheritance winds up with 17 owners of real estate scattered far and wide. So to sign one piece of paper, you need 17 signatures, and it needs to be circulated all over the United States. If, on the other hand, those 17 individuals are instead beneficiaries of a trust, and the trustee says, yes, we should sign this piece of paper, there's one signature instead of 17. There are many, many special circumstances that could lead an individual or family to want to create a trust for the benefit of beneficiaries who are youngsters, for the benefit of beneficiaries who have gambling problems, for the benefit of a beneficiary who has drug or alcohol use, substance abuse issues, and also often coming to the offices of Alexis and me and other elder law attorneys are families with people who have special needs, either children or adult siblings for whom the client wants to provide. There's also tax minimization planning and planning for actual or possible lifetime disability. As Alexis was saying, if your assets are in the trust and you're the trustee, but you yourself become unable to manage these assets, or maybe just tired of it, for Pete's sake. I've been doing it for 40 years and I named a trustee to take my place. They're still here, they're still willing, they're still able. I'm going to resign and let that successor take over. if you have a spouse for whom you want to provide in case you die first, and that individual either is incapable of money management or has no interest or experience or aptitude for it, then that's, again, another reason for the actual disability of your surviving spouse. There, your trust has provided for it without having to go through probate. So now, for the who and the how, this is definitely an elder law attorney issue, and I keep saying that, but let me just say that there are more sad tales told by elder law colleagues, like Alexis's story of the gentleman who needed to go to court for a guardianship to be wheeled down the hall. Don't go to a form book. Don't go online. Talk to an attorney who will discuss with you what your personal goals are and what your personal concerns and worries are. There are always trade-offs. No plan is always perfect without any shortcomings. So you need to know trade-offs and alternatives as articulated by your attorney, who has conversed with you to find out what's important to you and what you care about accomplishing. Then, how is it done? Here we are. This is probably about as thick as it would be, but that's because we double space it to make it easier to read. It's also in a fancy blue backer. You don't need that. In fact, you don't need a blue backer on a will. Actually, I have a deed in here too. We don't need a blue backer on a deed. I just did it for colorful presentation. So in this document, the attorney will embody your concerns and your goals in the right language to give the creator, you as the creator of the trust, or you and whoever else is with you creating this trust in the first place, naming the beneficiaries in the order that you want. So that, going back to our trust bucket with the names on the outside, it can say A and B spouses for life. Down below it would say Charlie after both A and B have died. But that's set out in this document. Don't try to go to a form book. Don't try to borrow your brother's. Don't try to copy it from the web. It is more dangerous than you can possibly know. Once the attorney draws that document and goes over it with you so that for the most part, you know what's going on there. I promise you there will be some areas that sound like legal gobbledygook, but the big parts, what you're worried about, what you want to accomplish, and the people you want to benefit should be all very plain and very clear, and you should be able to understand how that's going to work. Once you as creator, or whoever the creators are, sign, and at least one trustee signs, there, in Massachusetts, you have the trust. It's sometimes called an agreement of trust. Even if you're the initial trustee, it's like you having a handshake with yourself saying, this is the way I want it set up, and the trustee, yourself in this case, but even if it's Rockland Trust, they're going to say, okay, I see what you've written, and I agree to manage and administer it like that. Some states, as it says on the slide, some states do require funding of a trust in order for it to be actually in effect. Not so in Massachusetts, but one thing you're going to talk about with your attorney is, should it be a Massachusetts trust? Should it be another trust somewhere else? There are reasons. It would usually be a Massachusetts trust, but there are reasons, for instance, if you're wanting to benefit a person with special needs who lives in California, there may be a reason to have it be a California trust instead. How do you fund a trust? How do you change title to the property you're putting in the trust? The deed, it says in basic, A and B, deed to ABC Trust. And the property they're conveying is Blackacre, which Alexis and I know all too well from law school, because that's all they talked about in property class the whole time we were in law school was Blackacre. I never figured out where it was or why they ever called it Blackacre, but this deed is to Blackacre into our ABC Trust. Now, I drop it in the trust bucket, but a deed, once properly drawn and signed and notarized, a deed gets recorded in the Registry of Deeds. And eventually, that document finds its way, in unregistered land at least, it'll find its way back to the new owner, because the registry doesn't want to keep all that original paper. But I'm going to put it in the bucket to show you now, once I've recorded that deed with the Registry of Deeds, the title to that property is in the trust bucket. Fidelity, or Putnam, or Vanguard, or Schwab. If you have investment accounts, they can be in the name of your trust. How you accomplish that is to go to the brokerage and say, I have set up a trust. I need to fill out I want to put my brokerage account or accounts in the trust. You're not doing this with retirement accounts. No IRAs. No IRAs go in trust. But just plain old civilian investment accounts can go into your trust. Fill out the form from the brokerage and give them the copy of the portions of the trust that they require. It's usually the first page and the signature page. You can put bank accounts in there. I don't recommend just putting pennies in there, but yes, if you want to go to Bank of America and say, I made the A and ABC Trust, and I want to put this bank account in there, they will give you the forms. And the next time you get a bank statement, the statement will be addressed to whoever the trustee is. Let's say Jupiter trustee of ABC Trust at such and such an address, whatever the address you've given. That will put ownership of that bank account into the trust. You can put valuable chocolates or other items into the trust. You can put precious articles, seasonal or otherwise. And you always have to think ahead, so put some Christmas stuff in there. But seriously, don't put your car in there, okay? But virtually every other kind of property, however you would change record of ownership, that will do it to put it in your trust. Going back to the trust document itself for a minute, we've talked about the people creating it and the beneficiaries, how they're current or future. A moment on the choice of your trustees. It's a very important position. They can be individuals, they can be corporate entities. But you have to have people who are trustworthy, who will follow directions, who will pay attention to the needs of the beneficiaries, and most importantly of all, will not act in their own interest against the interests of the beneficiaries. Now, if A and B set up the trust and A and B are the lifetime beneficiaries, that's fine. They're going to do whatever they need. That's the couple putting their property in trust and running it just like they still individually owned it. But it's not going to be orphan property, and it doesn't have to go through the trust. So that once the document is drawn, that document and general trust law concepts, I mean, despite the fact you're wearing masks, you are breathing in air right now that has Massachusetts trust law in it. As far as I know, it's not carcinogenic or contagious or infectious, but that trust law that generally surrounds us in operating and managing and administering trusts in Massachusetts, together with the trust document, will determine what can go on with that trust. Where are you going to create the trust? We touched on this briefly. There may be, if you own real estate in another state, there usually is a way for you to still create a Massachusetts trust and use that to be your title holding trust for Massachusetts or Florida real estate or the cabin in Maine. And the lowest icon here is to get you to remember that if you have a special needs beneficiary who lives in another state, be sure to talk with the elder law attorney about how that needs to be reflected in the trust document. So when to set it up, your goals and your concerns. If you haven't set it up already, you couldn't set it up yesterday. But if you've got goals or concerns that could be served by having a trust, you can set it up tomorrow. Work with an attorney, talk about your goals and your concerns, and they will help you do that. We talked about how funding is required in some states, and funding the trust merely means putting the property in it. Some other trust terms, again, wiping away the mystery. To me, creator makes sense. That's the person or the people who are wanting to create this trust. But you'll hear other terms for that same role. As long as it's got an OR on the end, a donor is the same as a creator, a settlor, a trustor, a grantor. I apologize for the legal profession for making all these terms, but they're all the same thing. Revocable and irrevocable trusts. Start with the irrevocable. It's just what it means, just what it says. Those trust terms cannot be changed. Once you set it up, that's it. Some of the terms in the trust can be drafted so that in other instruments in the future, there can be flexibility as needed if circumstances should arise where it's important to shift. But the original trust document, if it's irrevocable, you can't change that. Revocable, on the other hand, is changeable, amendable, take-backable. You can revoke it entirely. It would be possible to say, I don't want this anymore. Two other terms to distinguish. You probably have heard of a living trust. Well, go back up one stage on the slide. A testamentary trust is trust language. It's as if the trust document was just sucked right inside the will. Trust language contained within a person's last will and testament. And there's your clue to what a testamentary trust is. We can't fund that trust. Remember, the will doesn't do anything till after you die. So we can't fund that trust if it is a testamentary trust. on page 7 of Little Mary Lamb's will. We can't fund that until after she dies. That's going to have to go through probate, but that's what a testamentary trust is. And sometimes, in certain cases, it's very important to have that. That, however, is weeds area that we're not going to go to. Then, a living trust is any trust that's not a testamentary trust. So if you go back to the revocable or irrevocable, either of those can be a living trust. So that's simple trusts. Trust 101, trust basics, trust demystified, I hope. And if you have recommendations for where I can get more socks, please see me afterwards. There you go.
Okay.
I'm just going to clean up the debris later. Unless, do you want to walk there?
She's serious about the socks, though. Excellent collection of socks. Which I hope you have named specific beneficiaries for your fabulous socks in your trust, Holly.
I have.
Perfect. Perfect. All right, let me, I just don't want to repeat what Holly said because you don't need to hear things more because she did a good job. Let me just scooch through for a second. So, all right, I'll just do this part of this quickly. So, and then we're going to get into something else. So to just finish out on the trust, so Holly explained like who, what, when, where, how, and why of a trust. And on her last page said revocable, irrevocable, living, testamentary trust. So you can just remember that top bullet. The way I always describe it is trusts come in many flavors. If your neighbor, if your brother says, I have a trust, you need a trust. If your neighbor says, I have a trust, you need a trust. People come in all the time and tell me, my neighbors, actually, I've had both. I've saw people, my brother says I need a trust because he has a trust. So you want to make sure you're going to work with an elder law attorney. You're not going to go get a form. You're not going to go on the internet, like Holly said. You're not going to retype your brother's trust because the one that he has is most likely going to be totally different from the kind that you need. The one that your neighbor has is going to most likely be totally different from the kind of you need. And you might not need one at all. So these are all questions to discuss with the elder law attorney. Quick rundown of different flavors. So the revocable trust, right? Holly said revocable, irrevocable. So revocable during your lifetime, like she said, you're in charge, you're the beneficiary. Successor trustee can step in and help you with whatever you put in that bucket, your money, your socks, your house. When you get tired of managing things, or if you get to a point where you can't manage those things, successor trustee steps in, avoids probate. And my favorite reason we like trusts is that there are a lot of what ifs built in for the inheritance. So most people say, 9 out of 10 people say, I'm going to set up a trust during my lifetime. You know, I'm the beneficiary. After I die, it goes to my 2 kids. Standard. Almost everybody does this. But then we can build into a trust. You can't really do this in a will. And you can't do this on a beneficiary form at your bank. But in a trust, you can say, but what if, this is the part where I knock on wood, what if one of my children is deceased? Where does her share go? What if my child gets divorced? How can I protect that share from the ex-husband? What if my child gets in a car accident? How do I protect that share from the other lawyer? What if one of my grandchildren becomes disabled? How do I protect that individual share? So that's another reason we love trust. You can take care of all these what ifs that aren't in your life now, but they might be later on after you've signed your trust. It's already built in. We've already figured out if this thing pops up in your life, we've already taken care of it on page 7. So that's another reason to do a trust. You can't do that in a will. You can't do that on a beneficiary form, all the what ifs. Irrevocable trusts. Irrevocable. Remember Holly said you sign it, it's done. It's a done deal. She also said there's pros and cons to every plan that you put in place with your estate planning attorney. An irrevocable trust, there's some great pluses. And I'm saying this because you're going to hear on the radio, you should have an irrevocable trust, or your neighbor's going to say, I did an irrevocable trust, you should too. So you need to know, irrevocable trust, the reason we do them might be mass health, nursing home planning, might be creditor protection, like if you own a business and you want to make sure that your business could never be, grabbed by creditors. If you, again, have that child who, that husband's a little shady, I want to make sure I can protect her inheritance from that guy. Tax planning, we can do with irrevocable trust. So those are all the positives. The downsides of irrevocable trust. During your lifetime, you are not in charge. You are not in charge. You have put somebody else as trustee in charge of that money. You've put somebody else as beneficiary of that money. So I'm just going to give you an example because this comes up all the time, and I'm sure you've already talked to, heard neighbors, et cetera, talking about it. Someone else, your neighbor's going to say, well, I put my house in an irrevocable trust so that the nursing home can't take my house. That can be great. Nobody wants to use their house to pay for a nursing home. But you need to know the dark side of that is you are no longer in charge of your house. Probably you named your kids as trustees. Your kids are now trustees of that irrevocable trust that you put your house into so the nursing home can't get it. But now your kids are in charge of your house while you're living there. If they want to sell it, well, no, that's not true. If you want to sell it and move, if you want to do a reverse mortgage so you can stay in your house for longer, and they're like, that's my inheritance. We're not doing a reverse mortgage. There's nothing we can do about it. So just be very aware when you're listening to people tell you, put your house in an irrevocable trust for a nursing home. There's a dark side as well. Other irrevocable trusts, life insurance trusts, that's all about saving on estate taxes. QPERTs are all about saving on estate taxes. We're not going to go into those now, but Susan wanted us to just really convey the idea that trusts come in lots of different flavors. Special needs trusts we're going to talk about a lot. We already talked about this. This is like one of those things you gotta, if you have the slides in front of you, you wanna put like 13 stars around it and arrows. You have to do your estate planning, your will, your trust, your beneficiaries with an attorney, most especially no matter what. If you have a special needs child, if you have a blended family, second marriage, if you have uneven distributions, if you're disinheriting somebody, you're giving 70% to this kid and 30% to this kid or 0 to this kid, don't try to do that on your own. If you are very serious about doing long-term care planning for funding your own long-term care and then protecting assets around that, you have to, absolutely have to, do your estate planning with an elder law attorney. And again, I know we've said this about 13 times. Do not use mass-produced forms. Don't use anything on the internet, except for that healthcare proxy I told you could find at Honoring Choices. All right, we talked about don't make your kid a joint owner on your bank account. We also don't want to put your kid as a joint owner on your house. A lot of people will say, well, I don't need to go see an attorney. I don't need to pay for a will. I don't need to pay for a trust. I'm just going to write this deed and put my daughter on my house, and then she'll get my house after I die, which is true. However, what if during your lifetime she ends up getting divorced? She's a joint owner on your house now. What if during your lifetime she gets into a car accident? She is a joint owner on your house now. So just really making that point that people kind of DIY will just throw their kid on as a joint owner. You don't want to do it on your bank account. You don't want to do it on your house. Unless we told you to, because sometimes there's reason to do it. All right, Susan wanted me to talk about special needs children, and I am very glad she did, because this is a topic that does not get enough airtime. And I know we've been talking for a while, so I'm actually not going to use every single slide I brought. And I know not everybody here has an adult disabled child or adult disabled sibling in their life, but I would still ask you to pay attention because you know somebody who does. You've got a a brother, a sister with a disabled child, you've got a neighbor with an adult disabled child, and a lot of parents of adult disabled child don't know about what I'm about to explain. So even if it doesn't apply to you directly, it would be a very good deed for you to keep your listening ears on, as we used to say in school, and pass on some information. So when we have an adult disabled child, the parent does a lot of things. As you might know, as that parent, or as maybe you're an aunt or an uncle or a neighbor, you've seen this. The parent of an adult disabled child is doing all the medical management, all the appointments, all the medications, everything. They're taking care of the living situation for the adult disabled child, they're managing the money, and they're also being mom and dad. So we always like to have people plan ahead. Who's going to take over all these roles for me? Because eventually there will be a day where I can't do all these roles. We like to have, remember we said when we turn 18 we should all do a healthcare proxy and a power of attorney? The same goes for adult disabled children. I've met plenty of cognitively disabled children who still have enough capacity, more than enough capacity, to sit with me, and I know they meet my legal threshold to understand what is a healthcare proxy, what is a power of attorney, and I can have them sign that. Because remember, we turn 18, nobody can speak for us, so everybody needs a healthcare proxy and a POA. And I stress this because if you have been told by a social worker, like, well, you need to go get a guardianship for your child, you might, but you might not. We might be able to do a healthcare proxy and a POA, which is way easier and way cheaper than guardianship and conservatorship for your child. Inheritances. Holly mentioned special needs trust several times. This is a biggie. When we have adult special needs children, like the Cardinal Cushing down on 53 in Hanover, people can go, I think you can private pay, but most people are there because they're on public benefits. They've got Mass Health, they've got a DDS housing slot. Through DDS, they get to go to the day program. So we want adult disabled children to be on public benefits because they get all those things, and to get your housing and your day program and your health insurance through Mass Health. You have to be disabled and you have to be broke. Disabled and broke. So a lot of people know that to be an adult disabled child actually requires a lot of money. You need housing, you need food, you need rides, you need medical care, you need fun. So there's this complete dichotomy. To have your public benefits, you have to be disabled and broke. But the fact of the matter is you actually need money to live on when you're disabled. So how do we do that? People will leave their money to their child in a special needs trust. So if you've got a special needs child in your life, you need to know that you don't want to leave her money outright, because then she loses her benefits, loses her Mass Health, loses her day program, which means she loses her friends and her dances and her clubs, etc. So we don't want to give her any money directly. She's got to be disabled and broke. So we're going to leave her money in a bucket called a special needs trust. And if you really wanted to, you could read the federal Medicaid statutes and the federal Social Security statutes, which come right out and say, like, yes, she needs to be disabled and broke. And oh yes, you can leave her all the money in the world as long as it's inside a special needs trust. Congress did both of those things.
28 years ago.
And haven't updated anything, especially the $2,000 rule. Oh my gosh. All right, we're gonna, so what is a special needs trust? Oops, sorry. It's a bucket, hopefully a fun colored bucket like this one. And again, it's pieces of paper. Where's Holly's trust? So instead of being called ABC Trust, it would be called, trying to think, not the lamb.
Pinky Williams.
Pinky Williams?
Pinky Williams.
Pinky Williams Special Needs Trust. So probably her parent, is Pinky a he or a she?
I prefer not to say.
Pinky Williams' parents, grandparents, aunt, uncle, godparents, somebody who wants to leave her money is going to set up the Pinky Williams Special Needs Trust. Right? They're going to sign it, set it up with a lawyer, And they're going to name somebody to be her trustee, you know, maybe her cousin, maybe her sister, maybe another lawyer. And into that trust, the parents, the grandparents, the aunt and uncle, whoever it is, are going to say, we're going to leave her whatever they want to leave her. Maybe it's 50% of our estate, 30% of our estate, maybe $100,000 out of our estate. Whatever they want to leave her is going to go into that special needs trust. And because it's in the special needs trust, it's not in her name, because for a special needs adult to be on public benefits, what do they need to be? Disabled. And broke. So that is why we set up special needs trusts, and that's what a special needs trust is. And basically you're going to name somebody who you think would be a good trustee for her, who's the right person to manage money for her. And it might be someone in her life, it might be a professional trustee. All right. Oh, okay, good, I did that quickly. All right, so that's all we're gonna say for the moment on trusts in general, and wills, and special needs trusts, and healthcare proxies and power of attorneys, and Susan has said we could take questions at the end.
So thank you, Alexis and Holly, a lot of information to digest. So we have one final speaker. So I would like to welcome Gwen Morgan. Gwen was the creator of a workbook called the What If Workbook. So we've talked about all of these documents and things that you need to have that will help you in various parts of your life, but how do we organize all of that and other information? So Gwen's here to talk a little bit about that.
Whew, that was a lot of information. Yeah, so I'm Gwen Morgan. I hail from down the road in Scituate, and I'm going to make it brief because we did talk about the Red Sox. So, yes, I wrote this workbook called the What If Workbook. My background, I was a hospice volunteer for years. I did a lot of work with seniors. My mom had Alzheimer's. She passed away, and we just didn't take the time or think of, this was 25 years ago, of what her wishes were or what she would have wanted, say, for her funeral, or what kind of music she wanted at her service or anything like that. So after years of working with seniors, I found that a lot of times it wasn't really great communication sometimes between the families. And a lot of things led to a lot of things. And I said, wouldn't it be great to have some kind of organizational, easy fill-in-the-blank guide to help us get our affairs together in one location? And so I created the What If Workbook. I'm going to make this really brief because it's late. So that has become my mission/ministry for the last 15 years. And I do workshops and seminars around the workbook and encourage people to follow what I call my What If philosophy. So one, to get their affairs together when you're well, of sound mind and body. You can make some good decisions. Communicate to your family what those decisions are, and write them down. I'll go over that. And then my biggest thing is live your life fully. You know, thinking about, you're going to, of course, you're going to get your trust together, you're going to get your work with an estate attorney, elder law attorneys, get all this stuff together, and it's going to give you such peace of mind. So in the workbook, I'm just going to say very briefly what it's about. You don't need the workbook. You can do it on yellow pads of paper. My thing is just to do it when you're well. So you want, like, who would you want to contact in case something happens to you? You want to put all your finances, of course, your banks, your checking account numbers, your savings account. Do you do online banking? In the latest version of the book, which I did a couple years ago, usernames and passwords. You know, can you get into, so say you're you're married, you handle all of the affairs in your house. Does your husband or wife, if you're the person, in my case, my husband worked, I handled all of our business stuff, whatever, and it scared me. If something happened to me, he wouldn't have a clue as to where anything was. So to sit down with that person, so usernames, passwords, to get into the cell phone, the online banking, you know, put it in a secret place. Like in my What If Workbook, I have, go to my computer, go to this crazy name document that I put in, ABC, whatever. And there are all my usernames and passwords, and then they have to be kept up to date, right? Because I've heard so many stories lately because of the computer world that we live in. Somebody passes away, and they don't even know where to start. So things like that. So credit cards accounts, where your mortgage is, where your car titles are, your DD 214 papers. That's a big thing for the veterans, for them to be able to get their benefits. And then there's the end of life stuff. You know, and for us to even talk about it, it's a really hard thing to talk about, right? But do you want to be buried? Do you want to be cremated? Where do you want your ashes scattered? Do you want them buried, or do you want them out at sea? What kind of service do you want? Maybe you don't want a service. Maybe you want a big memorial, and I'm part of UCC Norwell, which I'm happy some people are here, and Leanne is sponsoring this, which is wonderful. But we have a beautiful memorial garden. I would want a service. What kind of music do you want? Who do you want to speak? Maybe you don't want a service. You want it on a pond up in New Hampshire with just poems and a harp. And all of these things are your decisions, and my purpose for doing this is just to honor who you are, make your decisions. There's not a right or wrong decision, it's your decision. And then to communicate to your loved ones what those wishes are. Some people want just to, you know, when I pass, I want you to have an intimate dinner just with the family. Or, in my case, I want a celebration of life, an open bar, and I have in my workbook where the money's gonna come from, seriously. But it's all individual preference. Special gifts to loved ones and all of that. And I do the workshops and seminars, and I think we might be offering one after the first of the year at the Norwell CNA. But to get your wills together, get your trust together, who do you choose for that? How do you start the communication about that? So all those things. So to start the process now, because you never know. My dear 67-year-old sister passed away a couple months ago. We filled the What If workbook out, thankfully, years ago, but we hadn't updated it. So even then, because once you get sick, once you're ill, it's kind of hard to discuss it. So you want to do it just what if? You know, what if this is going to happen? And especially your end-of-life decisions, talking about the most and having that all together, and you have the healthcare proxy, but to have that conversation for whoever you choose as your healthcare agent, you know, I don't want to die in a hospital, I want to be home. Just comfort care, don't hook me up to anything. I want to be home, I want my dog, I want music, I want people to visit me, you know, just having those kind of conversations. You want to be sure you choose someone that has sort of your same ethical, moral look on life. You know, like they said about pulling the plug. A lot of people say, I could never have my spouse, I don't want to be kept alive artificially, but my spouse says they could never do it. So who do you choose? Who do you have? You want to choose someone who's strong, who's going to honor your decision in a hospital setting if that has to be so. Anyway, so that is really in a nutshell. There's a sample of the workbook back there, but just get your stuff together, write it down, communicate to a loved one. If you're single, choose somebody who you trust to do to make those decisions for you and take care of your end of life stuff. So thank you all for coming, because I know everybody has a lot of questions, so thank you.
Thank you. So thanks, Gwen. So we covered a lot of information tonight. As Gwen mentioned, we will look to host a What If workshop after the first of the year. So watch for that if you're local, in the newsletter, in our email blast, Facebook, and whatnot. So are there any questions written down that we have that people want to ask? Or if not, is there anybody in the audience who would like to ask a question? No, we did a good job answering. Oh, okay, sorry. I'm gonna bring the mic to you. Who had the question?
It's interesting that you said that about the passwords. I hadn't used my passwords for my laptop for a while, and I can't remember the question. So when I said that, one of them was about your first pet. So I was only going back 20 years, where when I first did that, I was much younger, and it was a different cat. So I've been locked out of my thing. And I also have a big family. So do you recommend letting multiple people know where you keep those things? Or is it really
I
there?
usually recommend, and there's a place in the book too. I don't know if I need this. I talk pretty loud. Is this on? What I recommend is choosing the person who's probably going to be your healthcare proxy and or your power of attorney, and sit down with them. And I suggest putting this like in a portable storage box, like a fireproof box, and you put in your, however you put it together, you know, your legal pads with all this information, your DD-214s if you're a veteran, your passports, your birth certificates, your jewelry appraisals, all of that in a box. And you talk to them and you tell them where it is, and you should hide it, of course, because people say, what if I get broken into? So in some obscure closet somewhere, I say put it in the back and put junk on it, but tell some person where that is. So even in the case of a fire, you can take it. In a hurricane, you can take it. But then let them know where it is. And, you know, make sure that they have your healthcare person, I think the attorneys will agree, to make sure that they have a copy of the healthcare proxy itself too, and the durable power of attorney. So if something happens, you can go to the hospital, and so don't hide it away. And they should, I always say they should. Shouldn't the person who is the power of attorney or the healthcare proxy have one on hand too? A copy, because you can copy the healthcare proxy. I don't know about the durable power of attorney. That's a whole different thing. Yeah, so I don't think you want to tell a lot of people. You want to do the people that you trust, because like they alluded to, sometimes it gets sticky and people do bad things. We all are you know, that's, yeah.
Are there any?
I have a question about the durable power of attorney. I always thought that it came into being just like a healthcare proxy when the person dies. This is new to me.
Go ahead. You did what everybody does, so this is great.
Thank you, Gwen.
Well, I want to make sure I'm talking about it right.
No, this is great. Everybody says what you said. So we have different hats that we wear. So when it comes to health, we put on our healthcare proxy hat to help somebody. When it comes to money and finances, so let's say my mother has named me as her POA, her power of attorney. So while she is living, I can go into the bank and put on my power of attorney hat and help her. Oh, incapacitated. Oh, you said dead, but.
Yeah, but there's two issues.
Wait, let me just finish. So then, well, you said the word dead, so I'm going to go there too. So then after my mother dies, I go into the bank and I put on my executor hat for her will. Or if she did a trust, I put on my trustee hat. So just to be clear, power of attorney is only while you're living. Because all the time people say, well, can't my power of attorney get into my stuff after I'm dead? No, power of attorney is only while you're living. So then you were asking, springing. Yeah, here.
Can only be invoked when the person is incapacitated. Really?
There are two different kinds. There is the one that is immediately effective, and there is also a type of power of attorney called a springing power of attorney, which operates much like the healthcare proxy, where in the document, in the power of attorney itself, it says, if I become unable to, or if two doctors certify, whatever the language says, then and only then does my agent or do my agents have power to act for me. I will hand it back to Alexis to see what she says. My position when I used to practice was that I did not recommend a springing power of attorney. If you are choosing someone who is trustworthy enough to have the enormous power to be your agent under a power of attorney, trust them not to do wrong by you when you can be checking the bank statements. Because if you don't trust them enough not to do wrong to you when you can check, then you're saying, but I trust you enough not to do wrong by me. Once I can't check my statements anymore, once I'm disabled. What's your position on springing powers?
Yeah, no, the same. I think, I wish we could do springing powers because that's what everybody wants, but banks do not like springing powers. So if you walk into the bank with a POA that has a springing power, the bank is going to say bye-bye. So that's why we don't do that.
Well, no, they can do it when they're incapacitated. Only when they're incapacitated. If the person can make their own decisions when they're living, they don't need it. But say they're in the accident and they're in a coma and they need to make some decisions.
Right. So a power of attorney, when you sign the document in our office, technically, whoever you've named, like I've named my husband, I've named my brother. Technically, I'm totally, I think, able to still manage my own affairs. But technically, because I've signed that POA, they can go out and do things in my name. However, they're not going to until I need them to, which comes back to the issue of you name somebody who you trust.
Thank you.
One other additional safeguard would be your agent could be immediately able to act for you, but they're not going to be able to do it without either, depending on where you're going with this, either an original signed power of attorney or a photocopy of the signed power of attorney. They can't just walk up to the bank a counter and say, I'm the power of attorney for Alexis Levitt, and I would like all the money in that account, please. That is not going to work. They have to show it. So you always want to talk with anybody you're going to consider naming as an agent. First, you've got to decide if you're comfortable and they're trustworthy enough. But then, will you be my agent under power of attorney? That's a lot of responsibility. Will you be my agent under the healthcare proxy? These are the things I would want. Are you comfortable doing those things for me, making these decisions if I need you to make them? And I had a friend whose dear friends of his parents outside Philadelphia named him, he was an attorney practicing up here in Plymouth County, named him as healthcare proxy and agent under power of attorney. And he had no idea until he was contacted by physicians down in the Philadelphia area saying, you're the healthcare proxy for this person. Hello. You can't do that. Don't do that.
Are there any other questions?
With a power of attorney, does the individual who you've given power of attorney to have a fiduciary responsibility that they have to act in your benefit?
Yes. Yes. So remember before Holly said we're breathing in trust law? It's all around us. So there's power of attorney law out there too. And so fiduciary, that is the vocabulary word. So your POA, your agent, has a fiduciary duty to act in your best interest. However, if they've already gone into your bank account and taken all the money and gone to Aruba, it's gone. And it's really, really hard to get it back. So they violated their fiduciary duty, but your money's gone. So again, name people who you trust.
Okay, hang on. Question over here.
I have just two questions on that third-party fiduciary. How does one find such a person? And how and when does that third party get paid?
Okay, so there's different fiduciaries. You might, you're going to want to name, we all want to name a healthcare proxy, we all want to name a power of attorney, and many of us want to name a trustee. The trustee one is easier to answer. If you have enough money, many banks will be happy to serve as your trustee. Not retirement money, but plain vanilla money, non-retirement money. A lot of time a bank will be your trustee. That's number one. On a special needs trust, there are professional nonprofit organizations out there who their job every single day is to be trustee of special needs trust for adult disabled individuals. The harder nut to crack is if you want a power of attorney and a healthcare proxy. So I have a list in my office of local colleagues and friends who like to be a healthcare proxy, like to be a power of attorney. So if you come into my office and you are a person who says, I don't have the right person in my life, I really want a local professional healthcare proxy or power of attorney, I'm going to look at my list and figure out really a good personality match. And then I'll have you go meet them and make sure you like them. So that's how we find the third-party fiduciaries. And then, so if you're hiring one of these attorneys who likes to be a healthcare proxy, likes to be a power of attorney, you're going to pay them maybe $250 an hour when they need to do things for you. And so, you know, I think for a lot of us, our experiences when healthcare hits the fan, there's going to be a lot of hours that person's spending helping you. But when things are quiet, there's going to be months and months and months and months and months where they're not doing anything on the healthcare front for you. And then on the POA front, you know, maybe they're paying your bills once a month for a half an hour. But then if you're selling your house, well, that month they're going to be doing a lot of work to sell your house. So that's the healthcare proxy and POA with a private attorney. If a bank is serving as the trustee on your trust, is that John right there? So John is with Merrill Lynch. So when Merrill Lynch and BOA are trustee on a trust, how do they get paid?
No, just when you need services. Oh, sorry. Just when you need the service, right?
Great. So he said a flat fee based on how much is in the trust that Bank of America is serving as trustee
So like
on.
Alexis said, if you're selling your house, if there's a lot of work involved, then, you know, it'll be more than if it's simpler, but
Yep.
a lot of banks will do that.
Okay, good. Does that answer the question? Okay.
Are there any other last questions before we wrap up? Anything veteran, anything VNA? Oh, thank you. So, as I mentioned, I thank you all for being here today. A lot of information covered. Our next session is in 2 weeks, and that's on creating your support circle. If you could do me a favor before you leave, please fill out your survey, drop it at the table real quick. If you're coming next time, you can bring it with you back next time. It just helps us get some feedback, more importantly, looking for topics for the future. There are sandwiches in the back, cookies, please help yourself. There's some information on the back table that you're welcome to help yourself to as well. Thank you so much for being here and joining us tonight. I hope you can get home and enjoy the Red Sox. So thanks for being here, everybody.